Hi, I'm Patrick Stegall. I'm a criminal defense lawyer in Memphis, Tennessee, and in this video I want to talk about no contact orders in the context of domestic assault cases. So if you have been charged with domestic assault in Memphis or any of the surrounding jurisdictions, you probably are under a no contact order with the victim. That means that after you were arrested and processed and booked, you made bail, but before they release you from the jail, they probably tell you that part of your bail conditions are that you cannot have any contact with the victim. That means can't see them, can't communicate with them, can't write them a letter or email, go by their place of work, can't go back to the house. This can be a very tough situation for people who live together, and usually domestic assault cases involve people who live together, people who have families. And they probably told you that when you were released from jail, and usually the judge tells you that at your arraignment date also. You may have been arraigned, had your first court date the next day or shortly afterward, and it's standard practice for the judge to read to the accused on that first court date the bail conditions, the no contact order. So if you're in this situation, this is something that you're going to have to deal with. One is to simply let it be and just keep the no contact order in place and let the case work out however it's going to work out. That does take time. You know, these domestic assault cases can take some time to work out. Anything in the legal system is going to take some time. In my experience, these take at least a few months. And that's the quickest that I see in my experience. So you cannot change the no contact order by yourself. Only the victim can do that. And that leads me to the second option. If the victim is agreeable to this, he or she can come to court and tell the judge, I want the bail condition changed. I want to have contact with the accused. I want him or her to come home and for us to be back together and to be able to communicate. But you, as the accused, cannot do that. I cannot do that as your attorney. Only the victim can do that. They have the power to come to court, talk to the prosecutor, talk to the judge. So if that is the situation, I can't help with that. We can get together and set the case to hear, or to go in front of the judge, to tell the judge this is what we want to do. So again, if you're in a situation where you've been charged with domestic assault, maybe it was an incident that just got blown out of hand, and you've now been charged, but the victim, perhaps somebody that you live with, somebody close to you, doesn't want to prosecute the case, or doesn't want to press charges or have this no contact order in place anymore, we can deal with that. Now getting the no contact order lifted and getting the charges dropped are two different things. Getting the charges dropped is really not the scope of this video. That's something I can talk about later, but just getting the no contact order lifted, or you can go back home and see your family or have communication with this person again, that is possible on their terms. If they come to me, or if a third party tells me or tells you they want to have contact, we can get them to court and go in front of the judge and get that part taken care of at least while the case is going on. Because if it's going to go on for 3 or 4 more months, then that can be helpful for you to go back home and get on with your life. So if you find yourself in this situation, you've been charged with domestic assault, you got this no contact order in place, the victim wants it lifted, I can help with that, and of course I can help with the rest of the case. So again, my name is Patrick Stegall. If you are in that situation, give me a call and I can help you. Thanks.